Let me share. I see a start broadcast if you want me to. Oh, okay. How is that? Is that working okay?
Let me check with attendees.
So maybe.
Let's see.
So sorry.
Attendees. Can anyone, our attendees, please just put in the chat if they can see us again, if you can see and hear us.
Yeah, and if the screen, I'll just change the screen. Is the screen being changed?
No, I think we are okay, Susan. Okay, they can see us now. It seems like we're back. So if you wouldn't mind sharing your screen again, then we can resume. Thanks everyone for letting us know. I think we are ready to get back, jump back into it. Thanks for your patience.
So the screen's not being shared yet. So let me go ahead and do that. And if somebody wants to let me know where it froze and left off, I'm happy to go right back to that slide. So if you want to just pop in the chat and let me know where it froze, I will go from there.
Yeah, I think, let's see, right around here.
Because I kept chatting.
Yeah. I think if we pick up here, we might be okay, Susan.
Okay. Let's pick up here, and hopefully we won't have to refresh constantly. So let me know. Again, we appreciate you letting us know if that happens again. I'm going to get a backup laptop going as well, just in case. Okay, so as I mentioned, so the farm labor contractors need to attest that all new non-supervisory employees need to be trained at the time of hire, and every 2 years. Okay, so that's, I believe, where we left off. It does need to be, the training needs to be administered by the licensee, so the farm labor contractor, or an appropriate designee. So we're going to talk about qualified trainer in a bit, and so we do need to ensure that the trainer is qualified to conduct the training. And whether you have someone employed with you, that person can conduct the training, or you would need to go outside that. And of course, the Department of Fair Employment and Housing has the training in English and Spanish on its website. And so you can utilize that training as well if needed. And that might be actually convenient for you, since at the time of training, if you're bringing people on, you might be bringing groups on at a time, but you can get those folks trained using that, and it's free of charge. So that's helpful. Okay, so all right, now the required training has to have minimum components, and you also need to utilize the, it's intended that you utilize the guide by the Department of Fair Employment and Housing. If you Google DFEH 185, you're going to receive, that pamphlet will come up. It was recently revamped. And so that's a poster that you should be handing out to every single employee that you're training, both supervisory and non-supervisory. And then you also need to have a record of the training on the form provided by the Labor Commissioner. And so I went ahead and put in the link to that form, so it would be easy for you to locate. So the farm labor contractor needs to provide the Labor Commissioner with a complete list of all of the materials and resources that were utilized for the training. So you do want to ensure that if you hire someone outside, or you do it in-house, that you keep all of your materials and resources. You are going to need to provide that, as well as the total number of employees that are trained in the calendar year before the month the renewal application is submitted. And that's also when you need to have your supervisors trained, is at that time before your renewal application is submitted. And then keep as a record the name of all employees who received that sexual harassment training for 3 years. So make sure you don't throw anything away. So, and then after 3 years, you can purge it, but you do want to ensure that you keep it for 3 years. So there are penalties associated with farm labor contractors who do not, and of course also, your license could be at risk as well. But there's also violations for each violation. So failure to train an employee. So if you have a crew, those can stack up. If you end up having 500, employees over the course of a season and you don't provide the training, you could have potentially substantial violations. So not only failure to train, but failure to provide the training in the language that the employee understands. Also failure to provide an ag employee with at least the minimum training. So they're, if the Department of Labor Standards Enforcement looks at your training materials, you do want to ensure that it's compliant. If you use their training material, I would imagine they're going to sign off on that being compliant. Okay, so again, you do need to provide the employee with a record of training and a copy of that sexual harassment poster. So ensure that you do, and when you do, it's advisable to actually have the employee sign receipt of that. And I also recommend that you hand them your sexual harassment policy. That's another requirement that the law requires, but it's a good reminder to do it at the time of the sexual harassment training. And then you can have an acknowledgement of receipt, and you have in a language that's understood by the employee, and you have them acknowledge the record of training, that they received the poster, and that they received the sexual harassment policy that the employer has. So if you give an ag employee a false record of completion, that's subject to fine, not surprisingly. And then if you fail to keep a record of the training, that also could be a problem. Okay, so now let's look at what is the sexual harassment training and education requirements for employers with 5 or more employees. So as many of you may heard, by 1/1/2021, all employers that employ 5 or more employees must have trained supervisors and non-supervisors. And this training would apply to growers. So it is a 5 or more employee requirement. And it is by January 1, 2021. And for both supervisors and non-supervisors, it's once every 2 years. So if you provided it in 2019, you don't need to provide it again until 2021. If you provide it in 2021, you can then go 2 years to 2023. So again, as we go through these slides, remember it's for the non-farm labor contractors. Okay, so supervisory employees need to receive 2 hours of the effective interactive sexual harassment training and education. That's outlined in the labor code. And then non-supervisories must receive 1 hour of the training. The new supervisory employees must be provided training within 6 months of assuming that supervisory position. And so for new non-supervisory employees, they must be provided training within 6 months of hire. And note, that's different than your FLCs, but this is for all the other employers. And yes, you can use the DLSE or the DIR training for supervisors and non-supervisors. Follow all the rules that are required for the FLCs, but you may use their training that they just recently put out. So the requirements do not override or supersede, as I mentioned, the requirements for the FLC. So if the requirements are different, FLCs must comply with those stricter requirements. So that means that the training must be provided in the language understood by the employee or interpreted, regardless of whether there's 5 or more employees, and non-supervisory employees must be trained at the time of hire. So the time of hire is different. There's not a 6-month grace period for FLCs and non-supervisory employees. And then your supervisor training is every calendar year for FLCs, as opposed to every 2 years for other employers that employ 5 or more employees. Okay, so now let's talk about the required components of the sexual harassment training under the applicable laws. They're essentially the same for both FLCs and employers with 5 or more employees. And so we'll go, so again, this applies to everyone when you're conducting training for supervisors and non-supervisors. There are additional training requirements for supervisors as opposed to non-supervisors. Everyone needs to be trained on these issues. So all individuals must be trained and understand that harassment based on sex gender identity, gender expression, and sexual orientation is prohibited and unlawful. So the objective would be to provide all the employees, trainees with information related to also negative effects of abusive conduct in the workplace. So these are requirements that must be, even though we're talking about sexual harassment training, California law has said as part of that sexual harassment training, you need to cover these issues: sex, gender identity, gender expression, and sexual orientation. And you must cover the negative effects of abusive conduct and also the prevention of abusive conduct. Also, develop, foster, and encourage a set of values in employees who complete the mandated training that will assist them in effectively preventing, and then effectively responding to incidents of harassment, and then also implementing mechanisms to address and correct wrongful behavior. So everyone can benefit from prevention, the effectively responding that's going to be geared to your supervisors, and then implementing mechanisms to address and correct wrongful behavior that will also be directed to your supervisors. So here's the required sexual harassment training content. So if you don't use what the DLSC has put out, then either you're a human resource person who meets the qualifications, or someone that you retain, you do need to ensure that it has minimal content. And there is a list for the farm labor contractors on that, the minimum content. So you need to have the definitions of unlawful harassment under both California law and federal law. The California law is the Fair Employment and Housing Act, and the federal law is Title VII of the Federal Civil Rights Act of 1964. So you may also provide a definition of and train about unlawful harassment on other protected classes. So there are many other protected classes under both state law and federal law. State law really picks up all of the federal protected classes. And so if you outline the protected classes that the Fair Employment and Housing Act has, you'll pick up everything. And I highly recommend that you include this because when training is being conducted on anti-harassment based on sex, gender, gender identity, sexual orientation, there are a lot of other protected classes. So it's a great time to make individuals aware of, race, national origin. National origin comes up, when people are might be harassing each other about the country in which they were born. Also, disability, mental disability. There are a whole host of protected classes, and so it's a great opportunity to share that with the employees so they understand that there are numerous protected classes, and they should stay away from joking about those things, commenting about those things, so that they can try to prevent claims against themselves and against the employer. So it'll overall help you as employers help prevent claims in the workplace. So FEHA, that's the California law, and Title VII, the federal law, the statutory provisions and case law principles concerning the prohibition against and prevention of unlawful harassment, discrimination, and retaliation of employment. So that category is required training content. So you want to ensure that that's in part of the training. And then also types of conduct that constitutes harassment. And really, you can put in the word unlawful harassment or the type of conduct that might constitute misconduct or a violation of your company's policy. Because not all conduct will necessarily result in unlawful sexual harassment, excuse me, but it could be a violation of your company's policy. So if you're conducting an investigation, for example, and you find that one person made an inappropriate comment to another person, and you write them up and you say, you engaged in sexual harassment, and you need to stop doing that, and therefore you're receiving this written reprimand. You don't necessarily want to make that legal conclusion that they've engaged in sexual harassment, because it actually is, quite a process before it gets to the point of being illegal. There's a lot of factors that go into that. But you do want to prohibit inappropriate comments in the workplace. And they are prohibited by your anti-harassment policy. And so one inappropriate comment may not give rise to illegal sexual harassment, but it will give rise to violation of your company's policy. So just a little tip to keep in mind there when you're following up on complaints of misconduct in the workplace. Okay. Other required training content that must be in the training is the remedies that are available to harassment victims in civil actions, including potential employer and individual liability. And so there are a multitude of remedies, and that must be included in the training content. Also, strategies to prevent harassment in the workplace, and then also the supervisor's obligation to report harassment, discrimination, and retaliation of which they become aware. So California Code of Regulations actually has in it that a supervisor, if they see something that, and really if they believe it violates company policy, or if they're even having to think about it, then it's probably something that shouldn't be occurring in the workplace. They do need to report that, and it's recommended that you have a centralized location to report that information to, such as an HR person, or if you're small enough, it might be the owner, it might be a general manager, whatever the case may be. But your supervisors and those individuals that might be out in the field, they need to report it. It is a mandatory requirement that it be reported. And then also in the required training, content must be an explanation to the individuals that are being trained that confidentiality is limited in the complaint process. Once someone makes a complaint, it triggers the obligation on the part of the employer to conduct an investigation. And the employer cannot guarantee complete confidentiality, because the employer needs to investigate and actually provide appropriate process for the accused, so that they have an opportunity to know what the allegations are and fully respond to them. Other required content is providing resources or noting resources for victims of unlawful sexual harassment, such as whom they should report. So, you may not necessarily want to put specific names, because sometimes there's turnover, but you do want to indicate at least position. And it does need to be more than one person. So if it's human resources person, it could be the supervisor, it could be a higher level manager, it could be any manager. And then of course your managers need to be trained to get it to the appropriate person for investigation. But you do need to let them know, of course, that needs to be part of your harassment policy as well. And you need to have multiple individuals that they can report to. And the reasoning behind that is, if it is the supervisor who's doing the harassment, the employee needs to be informed that they can go around that supervisor to someone to report the alleged harassment, so that it can be investigated and corrective action can be taken. Also required is you need to include the steps that are necessary to take the appropriate remedial measures to correct the harassing behavior. So that could include the obligation to conduct an effective workplace investigation, and then other remedial measures, verbal counseling, written reprimands, suspensions, termination. All of those are options. Again, the employer's duty is to end the harassment. So those are the types of things when it talks about having required training content, that not only you have that content, but you explain to the individuals that are being trained what those steps are and what the employer's obligation is. They need to take effective action to end any harassment that might be occurring in the workplace. So also what must be included in the required training content is what should an individual do if they are personally accused of harassment? What steps do they take? That needs to be also included in the training. Okay, so also essential elements of an anti-harassment policy needs to be included. And again, as I mentioned, that needs to be handed out as well. So the elements of the anti-harassment policy, and then how to utilize that policy if a harassment complaint is filed. Then again, as I mentioned, you need to provide the employees with a copy of that. And then, I would suggest that you have them read it and acknowledge receipt, and they can do that as part of their training process. But that's required separately under California law. Like if you're doing some research on farm labor contractors and what they need to do, you may not come across that requirement because that's in a different area, but you need to look at all of these requirements involving sexual harassment training as a whole. And then with farm labor contractors having stricter requirements with higher frequency and timing, and the translation interpretation. So you need to follow those, but then you also need to follow all of the other requirements of required content, and then also having a policy and handing that policy out. So again, also going back to the content, you want to have examples. So California law requires that the training be interactive. And so even if you choose to do the DLSE training, then if you choose to do the DLSE training, then you'll have examples in there, and it's intended and designed to be interactive. And there are requirements for online training to be interactive, and what it takes to actually be interactive. There's other trainings that you can do webinars, attend webinars where there's a live trainer, where you have, the practical examples coming in live and questions are happening live like we're doing now. But you can do role playing, you can have case studies, group discussions, factual scenarios, and then workplace hypotheticals. All of those, or any of the, you don't have to do all of them. Those are examples of what might be practical examples to really illustrate to the individuals that are being trained, what does harassment look like? How can we prevent it? What does discrimination look like, and retaliation, and abusive conduct? So those examples do need to include gender identity, which is going to pick up the transgender, definitions of transgender. What does that mean? Also non-binary. So maybe an individual doesn't identify as male or female. Gender expression, how one expresses himself, themselves, or herself. And regardless if it's consistent with the assigned sex at birth. And then sexual orientation, who that person is attracted to. So you want to ensure that the training is inclusive of these items. Okay, now let's get to qualified trainers. So you do need to have a qualified trainer conduct the training. So if you in the past have used, your crew leader to conduct the training and sort of relied on that, and they do a very short orientation and a very short, don't harass people, sign here, that's really not going to be sufficient any longer. It does need to be more thorough than that. It needs to be an hour long. So you do need to ensure that not only is the training have the required elements as discussed, but also that your trainer is qualified. So through a combination of training, experience, knowledge, they need to be able to train about what the definition of abusive conduct is, definition of sexual harassment, gender identity, expression, sexual orientation. And then, as I mentioned, I like to bring in all of the protected classes because it really benefits the employer, and it also can help prevent claims among employees. And then also the trainer needs to know needs to be able to train on how to identify behavior that might constitute unlawful harassment, discrimination, and retaliation, and then train on what steps to take if harassing behavior occurs in the workplace, and then how to report those harassment complaints. So your employees know, both supervisors and non-supervisors, what to do if they see something, how to report it, how to identify that behavior, and also what constitutes that behavior. What does it look like? What does it sound like? letting the employees know what is acceptable and what is not acceptable in the workplace. So also including obligations to report harassment. So again, supervisors, as I mentioned, need to report, so they need to be trained on that. I already mentioned how to respond. The employer's obligation to conduct an investigation of a complaint, what constitutes retaliation and how to prevent that. And I already mentioned the essential components of harassment policy, so the trainer is going to be training on that. The effect of harassment on harassed employees, workers, harassers, and employees, and same with effect of abusive conduct on the workplace and others. So California law intends for individuals to understand not only what harassment is, what it looks like, how to report it, how to prevent it, and the impact that it has in the workplace. And then, of course, practical examples. So you as an employer, whether you're a farm labor contractor or any other employer that has 5 or more employees, you can utilize multiple trainers, so long as in combination they meet all of those required qualifications. So they also have to be one or more of the following. So they either need to be an attorney, a human resources professional, or a professor or instructor. So in-house, as an employer, you're probably going to have, if you're going to have any of these, it's probably going to be the human resource professional. And there are requirements for that, which we'll mention. With respect to attorneys, should you hire an attorney to conduct the training, they can't be a brand spanking new attorney. They do need to be admitted to the bar for at least 2 years in any state in the US. And so their practice must include in that 2 years employment law under California's Fair Employment and Housing Act or Title VII of the Federal Civil Rights Act of 1964. Now, for your human resources professionals, they also need to have 2 years of practical experience, but it is in one or more of the following. So designing or conducting discrimination, retaliation, and sexual harassment training, or responding to sexual harassment complaints or other discrimination complaints, or conducting investigations, or advising employers or employees regarding discrimination, retaliation, and harassment prevention. And that also would apply to harassment prevention consultants and peer-to-peer trainers. So for the human resource professionals, it would be someone, that works for you, human resource manager, or there's human resource consultants or firms that you could pull from, but they do need to have this. So if you're hiring someone, you do want to ensure, and usually they self-regulate, and so they know whether or not they're qualified, but you do want to ensure that you have a qualified person in case it is ever scrutinized. And if one question is, if you're not an FLC, do you need to have them sign for the anti-harassment policy? The reason I recommend, so you have to disseminate, every employer needs to disseminate the anti-harassment policy. So that can be via email, it can be handing it out in person, it can be publishing it on an intranet. But what you want to be able to ask yourself is, if I needed to prove that, employee A received that particular anti-harassment policy, do I have a method of proving that? And so if they sign acknowledgement of the receipt, that's one method of proving that. If you email it to them, which a lot of you might be in a situation where they don't have email, that might be a method of proving that. So ask yourself that question. So there is a requirement that it's disseminated. That's a given. And then how are you going to prove that it was disseminated? Okay, so professors or instructors, they can be from law schools, colleges, or universities. They need to have 20 hours of instruction hours or 2 or more years of experience in law school, college, or university teaching about employment law under FEHA or Title VII. So you can see that, the requirements are not necessarily light, right? So California law does intend that the trainers have a working base knowledge on sexual harassment and all of those required components that must be in that training program. So classroom training is preferred. As I mentioned, California wants the training to be interactive. And so for in-person trainer instruction, that meets that need. The content's created by the trainer, provided to the employees, and it takes place in a setting in which the employees are removed from their daily duties. They can ask questions, they can interact, and so the classroom training is an acceptable form of training to have that interactive, effective training. You can also do, as I mentioned, the online training, so e-learning training, and this is what if you did utilize the DLSE, either one of their trainings that they have, that's what it would be, the e-learning training. And that is an individualized and interactive computer-based training. So the content is created by a trainer and an instructional designer, and it needs to include a link or directions on how to contact that trainer, who is available to answer questions or provide guidance and assistance within a reasonable period of time. And I believe, I'm not sure if I have it in here, but I believe that's 24 hours, if I remember. Oh, there it is, 2 business days, so it's 48 hours. So within 48 hours, they need to be able to have a question answered or guidance or assistance, whatever the trainee might be seeking. And then the trainer must maintain all of the written questions received. So if there's online training, then if that trainer receives written questions during that online training, they need to be retained. And all guidance provided as well. So for a period of 2 years after the date of the response. Webinar training can be internet-based, and the content, of course, is created and taught by the trainer, and it's transmitted over the internet or intranet in real time. So the employers that use the webinar training, they need to document and demonstrate that each employee who is not physically present in the same room as the trainer attended the entire training and actively participated with the training's interactive content. So discussion questions, hypothetical scenarios, polls, quizzes, tests, or activities. And so, so during a webinar training, there's the question box like you have now, and you'll want to say, if you're conducting that training via webinar, I'm going to ask a question. I want everyone to respond in the question box so that I can see what your answer is. So you can do that. You can have polls, and like a GoToWebinar, for example, does track the participation in the polls. And then you can also, of course, have quiz or tests and activities, etc. So you do need to provide the opportunity to ask questions, and you can have them answered, or they can otherwise seek guidance or assistance. And so whether that's during the training or immediately after, the methodology needs to be present for that. And then for 2 years after that, the employer needs to maintain a copy of the webinar, all written materials used by the trainer, and all written questions that are submitted during the webinar, and then document all written responses or guidance that the trainer may have provided during that webinar. So you do want to ensure that you have all of that retained. There's prep before the training, there's a little bit of prep after the training, including additional things that an FLC needs to do, such as the additional handouts of the record of training and that DFEH pamphlet. And on those, to the individual's question about the actual anti-harassment policy, the other 2 things that you do need to provide to, as an FLC to the employees, you do want to ensure that you have them acknowledge receipt. And that's why I was adding in there, go ahead and have them acknowledge receipt of the actual harassment policy too, because you're already in that process. Okay, so interactive training, questions that assess learning, skill building activities, and then hypothetical scenarios. So there's a whole host of interactive training examples that you can do, small group discussion questions that accompany hypothetical fact scenarios, etc. So again, you want to have the interactive training be a source of teaching the trainees more about how to recognize sexual harassment, how to prevent sexual harassment, and then what the impact of sexual harassment is in the workplace. So tracking training compliance. The employer may track its training requirement for each individual measured from the date of completion of the last training. So you can, if it's an every 2-year training or every year, you can go from the date of the last training, or you can designate a training year. Again, for farm labor contractors, your more stringent training needs to fall within the timelines that are provided there. So supervisors before you renew, and individuals at the time of hire, and then every 2 years after that. So if you're rehiring them every year, you have the time of hire, right? Okay, so training documentation. Employers must keep documentation of training for a minimum of 2 years, and it needs to include all of these things: the name of the employees trained, date of training, sign-in sheet, copy of the certificates, type of training, all the written recorded materials, and the name of the training provider. And so with that, I think I've left a little bit of time for questions, and I know I answered a couple as we went. So Veronica, I'll turn it over to you.
Yep. Thank you, Susan. I think that was incredibly helpful, especially in providing the latest updates. So we do have a couple of questions that came in. So here's the first one. What is the timing requirement for FLC supervisor employees? What is the time frame for new supervisors to complete the training?
For FLC, so what the FLC requires is before the renewal. So then you're going to go to the one that is, most most stringent, so to speak. So it is it's within 6 months of that promotion or hire. They need to have that 2 years. But it could be sooner than that if you're about to renew your license, because it needs to be done before you renew. So all supervisors need to have that training before the renewal. And then following that, if that's not within 6 months, then you need to follow the 6-month rule. So
thank you. Great. Next question is, can the 1-hour training be broken up into smaller sessions, or does it have to be a 1-hour nonstop session?
I do believe that it could be broken up based on my memory of reviewing the regulations. And if you wanted to send me an email that I can confirm that, I will be happy to do that. But I do recall seeing that it doesn't have to be all in one session.
Okay. Great. Let's see. Okay, there are some companies that offer a train the trainer. Is that enough to conduct the sexual harassment training?
Well, train the trainer is going to be a little bit different potentially. So if train the trainer class had all of the components, which I would imagine it should, of a supervisor training, if that's the one that you're trying to meet, or of the employee training, then it should be sufficient for that person who attended that training. Then, of course, if the trainer, once trained, is training, that trainer, that individual person, doesn't need to do a separate training because they're actually giving the training. So it would qualify. So hopefully that answers your question. But you just would want to ensure that it includes all the components that are required, and it likely would.
Thank you. And here is a question. I mean, they're all good questions, but this is interesting. So do seasonal employees need to be trained every time they are rehired?
So on the rehire, I would want to confirm that with respect to seasonal employees, because one thing that we do know is that once someone is trained, and let's say the requirement is every 2 years, then that certification can last for 2 years. So especially if you did the training, you have the certification, then it's likely 2 years. I do want to confirm that. I did look that up recently, and I know with certainty that is the case for sexual harassment in general, but I would like to confirm for farm labor contractors. And it may be that the farm, because I don't remember seeing it when you're reviewing the farm labor contractor requirements, and if it's not included in there, you could use the regulations that are regular for the sexual harassment training. If you want to be on the safe side, you would do it every time. But really what that would do is, potentially end up doing a 1-year training, right, for all of those non-supervisors. And the farm labor contractor harassment training clearly says train at the time of hire and every 2 years after that. So my best estimation is going to be that you would be able to fall back on the other sexual harassment training regulations in which you could rely on that certificate. But again, I would want to confirm that just to ensure there's not an expectation with respect to farm labor contractors and that seasonal aspect. So again, feel free to send me an email and I'll be happy to confirm that for you.
Okay. Thank you, Susan. And in terms of contacting you, should they connect with you in the main lobby, or what's the best? Do you have an email that you wouldn't mind sharing maybe in the chat?
Yeah, sure. Yeah, I'll put that in. Yeah, my email address is susan@hatmakerlaw.com. And I would be, again, happy to answer those questions. Just to, I always like to be, certain before I give you solid advice on that. But I do think that those are the accurate responses.
Great. Thank you so much. Thank you for sharing your expertise and your time. And thank you everyone for being here with us. The session went by fast. Thank you to our Ag Labor sponsors. And with that, we will stop the broadcast. We're right on time, so please enjoy the rest of the forum, and we'll see you in another session.
Great. Thank you, and bye-bye.
Thank you.
Mm-hmm.